Hello viewers, as promised I am back. In the last discussion we were taken up a discussion on negotiation and mediation, and today in the continuation of informal access to justice through these ADR methods, I am going to take up discussion on conciliation and arbitration. As a habit, I would be referring to yesterday's lecture quite often during today's discussion, and I hope you would be able to relate to those discussions. So, before I take up the today's discussion on conciliation and arbitration as a method for informal approach to justice, let me discuss the scheme of the study. So, as I am taking up two concepts, conciliation and arbitration, I will be taking up a discussion on definition, historical development. These I would be restricting myself to conciliation, and along with the conciliation I would be making a reference to arbitration. But when I take up law on conciliation, I would be restricting myself to Industrial Disputes Act and Arbitration and Conciliation Act. These two legislations had made a mention of conciliation as a method of resolution of dispute, but later on there were many other legislations which included conciliations. I would be making passing reference to those things. I may not discuss those acts in detail. When I come to arbitration for discussion, I would be taking up definition as usual, followed by the process of arbitration and very important aspects as to what could be arbitrated, what cannot be arbitrated, what are the remedies available with arbitration process in case you are not happy with the outcome of arbitration. So, this is how the briefly I would be dealing with the discussion on scheme of the study. So, let us start with today's discussion. Before that, let me introduce myself. Dr. B.S. Patil. I am working as assistant professor at V.M. Salgaonkar College of Law, Goa, and I would be making a presentation, as you all know, and this is my second presentation on the same theme. So, when we talk about conciliation, what is this conciliation? For your information, conciliation and mediation looks to be very similar, and the role of the conciliator and mediator also seems to be identical. In this situation, how do you differentiate between conciliation and mediation? So, there has been various attempts have been made to discuss. The problem is there is no consistency shown by the legislatures. Sometimes legislatures use it interchangeably, sometimes they use it separately, sometimes they treat it as entirely two different authorities. So, just briefly we will understand what is conciliation is all about. Now, conciliation, like mediation, is a persuading authority and is going to pursue the parties to come to an amicable settlement of the dispute. He is majority time a non-adjudicatory authority, and he would not be adjudicating on anything, and definitely is a non-adversarial process where parties are treated as friends of each other rather than adversaries. So, in this whole process there is a third party who is known as a conciliator, and this third party has to be impartial, independent, and he would be discharging the role which is called as enabling role, and he would be empowering the parties to come up with an effective, efficient and smart agreement between them, and whatever outcome would be satisfactory to both the parties and which is acceptable to both the parties. So, these are the basic duties of the conciliator, that is enable the parties to come to satisfactory and acceptable settlement of the dispute. Conciliation basically works with mutual determination. Now, mutual determination means it is not somebody else deciding for the parties, but it is parties who are deciding by themselves, and when parties decide by themselves, they are coming up with mutual agreement on the disputed area, and it is a consensual nature. Again, it is not forced upon the parties, parties voluntarily agree for it, and if parties are not happy with it, then the parties are allowed to walk out of this whole process. And it is actually a friendly search for an amicable solution. That is what conciliation is about, a friendly search for an amicable solution. The most important characteristic of this conciliation process is absence of procedural constraints. When you go to court, when you go to other authorities, they are bound by the procedures. Until those procedures are fulfilled, they are not permitted to proceed further, and all those procedural restraints are absent. And more importantly, and I am very happy that there are no formal technicalities involved in this. Therefore, no order, no discussion and no agreement would be set aside for not following those formalities. In addition to enabling parties, here is a man called a conciliator who is going to visualize the options, who is going to encourage parties to come up with the options, he is going to encourage parties to come up with a settlement of the agreement based on those multiple options. And what is considered in this whole process is the interest and the priorities of the parties. It is not the rights and liabilities, but it is the interest which is the driving force behind the whole conciliation process. So, therefore, when we talk about conciliation, we are talking about a process where the interest of the parties are protected, and it is protected by themselves, not by anybody else. So, this is what the conciliation is all about. I hope you have got a fair idea about what is conciliation. It is somewhat similar to negotiation, it is similar to mediation, and I stand by the statement that it is an improved version of negotiation, because there is a third party who is taking care of it. So, when I am talking about conciliation, you might be feeling that I am introducing a new concept to the Indian legal system, but I am afraid you are wrong. It is not a new concept for Indian legal system. It was existing in ancient time, because the Kautilya in Maurya dynasty time had proposed this conciliation, and it was utilized to a very large extent during that time. Himachal Pradesh High Court used this concept, that is conciliation courts, for resolving most of the rent disputes in 1980s, and they were very successful with this. With the success story of Himachal Pradesh High Court, the Law Commission of India made a series of recommendations for introducing conciliation in the Indian legal system. 77th and 129th report of Law Commission suggested that we should go for conciliation as one of the important mode for settlement of disputes. In addition to the Law Commission, Malimat Committee also recommended conciliation. They went ahead a step and stated that conciliation could be part of criminal justice system also, where they tried to introduce plea bargaining concept, and they were successful in introducing it. So, from where all these ideas came, that is suggesting conciliation courts, that is by Himachal Pradesh High Courts, suggestion from Law Commission, suggestion from Malimat Committee. It is not that it has come from vacuum. There is a lot of work going on in international community on this. So, United Nations has established an organ in Hague, that is United Nations Commission on International Trade Law. This United Nations Commission on International Trade Law is popularly known as UNCITRAL. This UNCITRAL organ of United Nations introduced model law for ADRS. In 1980, they introduced a model law for conciliation, where they said that all the states should come up with the conciliation law in their local municipal legal system on the line of the model suggested by the UNCITRAL. Similarly, in the 1985, arbitration model law was proposed by UNCITRAL law, and the Indian legislatures picked up these two concepts of 1980 and 1985, introduced into our Indian legal system, and they called it as Arbitration and Conciliation Act 1996. So, this is an important development in the international community. We the world as a citizen of India. Now, we are thinking of becoming citizen of the world. Globalization came up with a concept called global village, and if you want to convert the whole globe into one village, we need to have one legal system, and this is one step towards having a common legal system, but anyway it is concerned with commercial law. So, if a business community wants to move from one state to another state, they need not worry about the foreign legal system, because they are going to have similar or sometimes identical arbitration laws, identical conciliation laws. In case of dispute, the matter could be resolved, because there is no surprise pack in this whole process, because we have a common legal system as far as arbitration is concerned. So, therefore, it is one concrete step towards concept of global village.